an insane motion in the Young Thug YSL RICO trial. In addition to that, we are now hearing the Manhattan District Attorney threatening the judge not to overturn Donald Trump's conviction. Now, we're going to talk about a lot of this in today's video. If you haven't already, please take a second, hit the like button for the video, subscribe to the channel. I really appreciate you guys. You guys are absolutely amazing. Now, let's first talk about this motion, which is for the defense team to stop talking about this case in the media. Now, I know how this sounds coming from Fani Willis's office, but many have already said that it's a little bit hypocritical that she, as she's always complaining to the media about her challenges. And you guys remember how Judge Scott McAfee has repeatedly told her not to use the race card about her election interference case against Donald Trump, right? Oh, yeah. She showed up in the church, in the pulpit, talking about the Donald Trump trial and how the judge was being unfair. I mean, she showed up in this women's convention talking about Donald Trump's trial and the judge. And I mean, the line had been crossed so many different times. And yet she's all over the place saying that she's getting all the negative criticisms just because of the color of her skin. Oh, yes, guys, the race card has been pulled multiple times. Now, what's really peculiar is that this case has been going on for about 2 years now. So why is the prosecution suddenly taking an interest in what the defense says to the media? I mean, this reminds me that there was a lot of pressure to remove Judge Ural Glanville from this case, given how he carried himself in court. It was nothing short of embarrassment. So after a secret meeting with a key witness and the prosecution was divulged, clips of the judge reacting to this literally went viral on social media, went viral on YouTube, TikTok, you name it. And it brought to question if he was indeed biased or maybe even working for Fani Willis's office at the time. And as we know, Judge Ural Glanville, well, he's out of the picture now. Now, we now have a new judge who has a lot of important rulings to make, and this gag order is one of them. Take a listen.
Tonight, we are following a new series of motions in the ongoing YSL RICO trial involving Jeffrey Williams, known as rapper Young Thug, and 5 other defendants.
Right now, defense attorneys say they're hoping their clients can get out on bond or have a mistrial declared. However, prosecutors want a gag order issued. 11 Alive's Grace King explains tonight what's at stake.
We'll all be here without the jury trying to get as much done as possible.
Judge Paige Whitaker wasting no time after recently replacing Judge Ural Glanville. Now she's considering how to proceed with the YSL RICO trial and the various motions filed by both sides.
Which does not mean I'm inviting them. It just means if there are some necessary ones that we need to consider. Obviously, I want them briefed by both sides.
Attorneys for 4 of the 6 co-defendants want the judge to declare a mistrial. Attorney Daryl Cohen, who isn't affiliated with this case, tells 11 Alive those requests are likely more strategic than anything.
What I say is not necessarily what I do. They're lawyers.
So what was that like? Do as I say, not as I do, kind of like how your parents told you when you were a kid. What's going on, John Lake?
Lawyers don't want to go through it again. So asking you for a mistrial is really more setting a record for appeal if they are convicted.
3 of those defendants are also asking to get out on bond.
It's been so long, they're alleging that because they've been incarcerated for so long, that they're not getting justice the way justice is meant to be.
Well, I mean, this is what a lot of folks in Fulton County have been complaining about for a long time. Innocent people sitting in jail for extended periods of time just because the district attorney hasn't gotten around to processing their case.
Plus, prosecutors are weighing in on how the case should proceed. They filed a new motion for a gag order that would stop the defense from talking about the case outside of court.
Judge Whitaker has got to review as much of the case as she can so she can be on board and know what she's ruling on.
Judge Whitaker will begin hearing these motions Tuesday morning. She hopes to get through them pretty quickly so they can resume trial.
Wow. Okay. So does this mean that the prosecution team isn't in favor of attorneys speaking out in public about their cases? What's going on, Sam Pam, British Gray? What's going on? Good afternoon. Hope you guys are doing well. Happy Friday, guys. Hope you guys are doing well on this beautiful Friday. But yeah, because they have to take a look at their boss if this is the case. If they don't want the prosecution, if they don't want the defense team to be talking about their cases, well, the prosecution should not have been talking about their cases either in multiple different public forums, right? We saw it with Fani Willis. We saw it with DA Fani Willis's office or prosecutors, the team. And so she's referenced an order from Judge Scott McAfee at a women's event earlier this year saying that she was told not to play the race card. But you know what she said? She's going to talk about it anyway with the head, with the neck movement. And I was waiting for her to go like this and literally just kind of just go full ghetto on him. Anyway, remember what Scott McAfee told her about this being legally improper? But Willis also didn't care about that. And this is kind of the hypocrisy that we've been seeing, that we've been hearing called out here from her own team, because they just don't want her. They don't want others doing what they're doing. That's basically what they're trying to stop here, right? And here's what Chief Deputy District Attorney Adrienne Love wrote about it. She says that some statements have to be stopped. Now, this includes attorneys' views and opinions about the case itself, opposing counsel, the now former judge, the jury, the outcome, and of course, the guilt or the innocence of specific defendants. And here's a few examples that they want shot down, all right? Now, you guys remember when Judge Ural Glanville threatened defense attorney Brian Steele with jail time? Big, huge shouting match, threatened a man with jail time. Then the judge stood up and walked out of the courtroom. So this is in line with a secret meeting that the prosecution had with Kenneth Copeland and the judge in the Young Thug YSL trial. An ex parte conversation that ultimately led Judge Ural Glanville being removed from the case. In a statement, Brian Steele said that the former judge and the prosecutors have run afoul of their duties under the law, which the results we now see that the law has sided with Mr. Steele. Now, another instance actually came from a podcast where DeMonte's Kendrick defense attorney, Keith Adams, he talked about the recusal of Judge Ural Glanville. And a lot of folks were calling for the judge's recusal. Comment down below if you were one of them. Now, Adams argued that they all wanted nothing more than a fair trial. That was all they were asking for. Now, again, this is something that everybody deserves here in our country. Now, the next example was a statement from the defense attorney, Doug Weinstein. Now, he says that he respects Judge Ural Glanville, but said that he just simply became biased over the course of the case, arguing that they want this trial to happen in front of an unbiased judge, but noted that the only outcome at this point forward should be a mistrial and a bond for Willis. Now, the judge in this case, as you guys have heard, is Judge Paige Whitaker. Now, she hit the ground running hard on this one as she convened an attorney-only hearing to review the progress of the case and to establish new rules for the continuation of the trial. Now, there was a previous judge that was placed before her. That was Judge Shakira Ingram. Now, something interesting happened with Judge Shakira Ingram. She promptly recused herself after she filed a motion disclosing her previous court-related affiliation with one of the co-defendants that were involved in the trial. So Whitaker on her end says that she wants things to move efficiently and expeditiously, which could be very good news because this trial has been going on for a long time now. She also laid down some ground rules that everyone is expected to be abiding by. So here's a few of them that kind of caught my eye. What's going on, Catalia? Court will begin by 8:45 a.m. and will end at 6 p.m. each day. No snacking or eating is allowed unless the day goes a little bit longer, where they're working through lunch or dinner. Defendants cannot use headphones during the trial, which includes wireless headsets. No more extensive wardrobes for the defendants, and decorum between attorneys in the courtroom and disruptions are to be kept to a minimum. Now, what's really funny here is that the AirPods They were supposedly used because the defendants were getting bored. Now, I don't know. If you're potentially about to be thrown in jail based on the outcome of the trial, I don't know how I could possibly find myself getting bored in there. I'd be concerned. But anyway, apparently the defendants were getting bored and they were wearing and listening to AirPods, whatever, to which Whitaker responded that they're not going to get bored from this point forward, alluding to her idea that she wants to keep things moving. She also addressed the decorum between the colleagues in the court in a very delicate way. She basically said that she's familiar with the tempers that have flared up within the process of this entire trial. This was very evident between the prosecution and the defense team, saying that some individuals have been less than professional, which reminds us that Fani Willis's chief deputy district attorney, Adrian Love, got into a shouting match with Judge Ural Glanville about the evidence. So I don't really think that we're going to see who knows what we're going to see in the future, but I don't think that we're going to see an exact repeat of the same scenario, but only time will tell. I know it's kind of early, but the difference between Judge Ural Glanville and Judge Whitaker is huge. But of course, I think it's only a matter of time until we see just how different the two will be when it comes to the rule of law. Now, we also have heard multiple threats coming from the Manhattan District Attorney urging the judge not to overturn Donald Trump's conviction. Take a listen to this here, guys.
Manhattan's district attorney is urging the judge in Donald Trump's hush money case to reject the former president's bid to toss out his conviction on immunity grounds. DA Alvin Bragg argued in a filing made public yesterday that the Supreme Court's recent decision on Trump's immunity for official acts while president has no bearing on his conviction on charges of falsifying business records in New York. Bragg?
I don't know how this guy is getting away with half the stuff he does. And I think it's very clear that DA Alvin Bragg has a personal vendetta against Donald Trump, or maybe someone's paying him to keep coming after Donald Trump. What do you guys think about this? Because it just seems like, from the very start of Trump's case here, DA Alvin Bragg has literally just been manufacturing stuff out of thin air, throwing stuff against the wall, and then just kind of hoping that something sticks here. I mean, you had the DOJ, you had the feds, you had all these large federal bodies looking at Donald Trump's cases in New York and saying, no, they're not worth pursuing. But you had DA Alvin Bragg decide to upgrade a misdemeanor to a felony and pull in Stormy Daniels and all these other folks, Michael Cohen, Judge Juan Merchan into this to create a fake trial to be able to label Donald Trump as a 34 count felon. This was their goal all along. But let's hear what DA Alvin Bragg's up to now.
Bragg contends that the charges exclusively stem from conduct for which Trump is not immune. The former president's attorneys have argued the Supreme Court's presidential immunity ruling should lead to the case being tossed entirely. Joining us now to help us sort it out, former litigator and MSNBC legal correspondent, Lisa Rubin. Lisa, good to see you again. So let's talk about this case. Do you think the Trump team's arguments have any merit? Because it is striking, I think, to most people watching this saying, well, wait a minute, this all happened. This is about conduct that happened before he was president.
Yeah, and it's important to sort of take a step back and remind people that the Supreme Court's immunity ruling isn't just about immunity from liability. It's also about immunity from the use of evidence. And that's what this fight is really about. It's not them saying, hey, he should be immune from prosecution for things that he did largely in 2015, 2016, and then privately. It's more that they say that there's a bunch of different pieces of evidence used at the trial that stem from the period of time during which he was president and even relate to his official acts as president that should have been excluded and without which the jury could not have come to the verdict that they reached.
Wow. So even MSNBC is essentially coming out and saying that that this evidence should never have been used against Donald Trump. This evidence, this was all associated with official acts as Donald Trump was president at the time. So this goes on to show how corrupt the judge was. Number one, DA Alvin Bragg knew that he knows the timeline for which the evidence was collected against Donald Trump. So you would know that this is during Donald Trump's presidency. So there is so much that should have been thrown out. And if you guys remember how many times Alina Habba, one of Donald Trump's attorneys, has come on and essentially given us updates, because if you guys remember, they wouldn't allow cameras into the courtroom in Manhattan during the Judge Juan Merchan hush money trial, as it was popularly called. They would not allow cameras in the courtroom. So the only updates we could get were from Michael Cohen, who we all know to be a professional liar, Donald Trump himself, whenever he would come out of the courtroom. We would hear from Alina Habba, who would also speak on behalf of Donald Trump, but our information was limited.
So this would seem to put into question, whatever the next steps are, the sentencing date, which is mid-September, I believe. How confident are you that that will happen when it's scheduled?
Well, I think, first of all, the judge has to make a determination about whether or not there's going to be a sentencing. But what's really important here, and I think this plays into the political calendar here too, is that the judge has already committed that he's going to make a decision about whether to set aside the verdict by September 6th. So when you hear the Trump campaign sort of backing away from the anytime, any place we'll debate Joe Biden, which should have applied to Kamala Harris as well, note that part of that may be contingent on what's going to happen on September 6th. If this conviction is upheld, as many people suspect, you can understand why Trump would be very eager to avoid a debate with the person we are all referring to now as the person who's prosecuting the case, the biggest case against Donald Trump, if he is still going to be a man convicted of 34 felony counts here in New York.
Now, here's the other thing. Like, if this evidence cannot be used, I mean, we've already heard from the Supreme Court's ruling on this. This is one of the reasons why the sentencing for Donald Trump has been postponed. But if this evidence couldn't be used, then you have to declare this a mistrial. And there's no way Donald Trump could be even a felon, because this evidence would be null and void. It would be invalid. So this argument is definitely something that Donald Trump's legal team is going to be bringing to the forefront here.
Sam Stein, the legal and the political completely intertwined.
Yeah, it's wild. We could end in September with a presidential campaign coming to a crescendo, a potential debate, and one of the candidates facing a sentencing in his criminal trial. Lisa, I just want to go back to what Jonathan said. The sentencing itself, what is the likelihood that we do end up seeing some sort of action prior to the election? And I know you're in the legal punditry, not the political punditry, but I'm sort of curious for your take. How would you imagine the Trump people are approaching this on a psychological level? The Bragg indictment and conviction did help them, but that was in the context of a primary campaign. This would be in the context of a general election coming to a close.
I agree with you. Again, my larger frame is always legal and not political. But as you noted, the legal and the political have all but collapsed into one here. And I do think that they are eager to avoid a sentencing, because a New York State sentencing is something that a future President Trump can't wish away. He can't dismiss. There's no Department of Justice policy or executive power that could rescue him from this case. And I do believe that the New York DA here will ultimately have the better of the argument, because even if all the evidence that the Trump folks say should be excluded is excluded, they make a great argument in the middle of their brief about all the other evidence that supports each and every element of the falsification of business records counts that were sustained against Donald Trump. That means we are likely barreling toward a September 18th sentencing. That's a firm date. We'll see if they can somehow persuade Judge Merchan to change that. But if, as I suspect, on September 6th, he comes back and says, I'm going to keep this conviction, then September 18th is the date for sentencing, Sam, and there's nothing that a former or a future president could do about that.
Well, we'll be.
Well, this is going to be very interesting here because, again, you know, a lot of this evidence should not have been allowed, should not have been permissible in the court. Now, the jury has come to their conclusion based on all of the evidence. So even if there was some other evidence, circumstantial evidence or whatever that was legitimate, it was all kind of like blended up like a big, like a smoothie into the trial. So at the end of the day, all of the collective evidence had an influence on the jury. Not to mention the fact that you're in New York City, where 90% of the folks in New York voted against Donald Trump, so it was already biased to begin with. Not to mention the judge is pretty much unqualified to even be presiding over the case. But the simple fact of the matter is that you had evidence that was presented that should not have been even admissible in court, and this influenced the jury. This is a mistrial waiting to happen. But what do y'all think? Hit me up in the comment section down below, guys. If you haven't already, hit the like button. Make sure you're still subscribed to the channel. I don't know why people keep getting unsubscribed, but that's what I'm being told. I look forward to seeing you guys on the next one. And make sure you check out my previous video. I did a previous, this kind of reminds me of the video I did last night, where I highlighted New York Attorney General Letitia James. And in this one, I was discussing how the state has just sued Letitia James and is now actually trying to protect former President Donald Trump from the sentencing in the New York case. So this ties right into this one. So make sure you check that video out after this one. Anyway, thanks for liking the video. Thank you for subscribing. I'll see you on the next one.